Hello everyone. So, we are in week 3 of the conflict management through mediation course. And in this week, as I have already discussed in my introduction video, that we are going to elaborate on the concept of mediation and its features. So, before I move on to elaborate about the concept of mediation, I would like to take a moment to elaborate about the development of mediation. See, mediation is not a new concept to us because when we look after our ancient period, we can feel that like mediation has a very broad historical background. That is, this concept of mediation is deep rooted during the times of Mahabharata and even during the time of Ramayana, wherein Lord Rama mediated between Sugriva and Bali, and Angad mediated between Rama and Ravana, and by Lord Krishna between Kaurava and Pandava. So, we have already witnessed the examples of mediation in the long back, and coming to in the future arenas, we have already witnessed in the recent past, like the panchayat system, wherein the panchayat used to resolve the disputes by means of panchas who were acting as a mediator, and those panchas were used to be called as Pancha Parmeshwara, who used to resolve the dispute. And with the advent of the Britishers, we have witnessed the growth of mediation, wherein the Civil Procedure Code have included the other methodologies of resolution of dispute like arbitration they included, but later by inclusion of section 89 under CPC, we witnessed the tremendous growth of mediation in the field as a method of resolution of dispute. And at present, what we can witness is like there are various legislations which are also recognizing mediation, like we have Commercial Codes Act, Consumer Protection Act of 2019, we have Companies Act, Industrial Disputes Act, we have Banking Ombudsman Scheme which recognizes mediation, and various other legislations which have already recognized the principles of mediation. And with this recognition, before I move on to elaborate the various definition of mediation, I would like to quote few of the authors who quotes about the mediation. Joseph Graham quotes, "An onus of mediation is worth a pound of arbitration and a ton of litigation." So he prefers more mediation when compared to arbitration and litigation. And Susskind and Babbitt quotes, "Successful mediation should result in cessation of disagreements." So as we all know, like the conflict, disputes, disagreements, angerness is the part and parcel of one's each and every human being. The disagreements come in our day-to-day life, and with respect to all those disagreements, it's very difficult for us to go for a litigation or for any other dispute resolution mechanism. In that circumstances, the mediation will be a helpful tool, and in case if the mediation is successful, it results in cessation of disagreements. And Abraham Lincoln quotes that, "Discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the normal winner is often a loser in fees, expenses, cost and time. Here, the Abraham Lincoln quotes that, like, discourage litigation, and he's quoting, although if at all you are a winner in a litigations, you are often a loser because you have paid the fees of the advocate, the court fees, the expenses of the in getting the litigation, or the cost and the time which you have invested in litigation procedure. And that is why Abraham Lincoln says discourage litigation. But to critique the Abraham Lincoln's quote, wherein he has used the term compromise. See, in case if you compromise something, that doesn't mean that you have win or you have won something. So that is why I critique on the Abraham Lincoln's quote with respect to the term which he has used, that is compromise. Because in case of mediation, the parties won't compromise. The parties, both the parties will win, will stand on a win-win position, and how it will stand on a win-win position we'll be discussing in the upcoming slides. So here, let us now focus on the concept of mediation. As we all notice how mediation is developed since the ancient period, and that is why we call a mediation as the ancient art of peacemaking, and it is an ancient and honorable process for the settlement of conflict resolution that involves a neutral third party between the two conflicting parties, and it is essential a search for a solution by the parties to the dispute themselves under the guidance of a third party. So here, the third neutral party is only assisting the parties to search for a solution, and his role as a mediator is only to facilitate or to guide the parties to reach a solution. And that is why a mediation is termed as an informal process, wherein a trained mediator assists the parties to reach a negotiated settlement. So how the mediator assists the parties? That the mediator assists the parties or facilitates the parties in order to negotiate themselves on the stance, on the disagreements which they have or the dispute they have, and based on that, in case of a negotiation process, they reach at an amicable settlement, or we can also term it as a negotiated settlement, and with the help of a third neutral party called mediator. A mediator brings the parties together face to face in a private and a confidential setting in order to facilitate the mediation process, or to facilitate it, to negotiate among themselves and reach at a settlement. Here we are required to take a key note that the mediator does not impose a decision on the parties. The mediator doesn't have any right to impose a decision on the parties, neither he has a right or neither he has any right to provide opinion or any views on the discussions which the parties are been making. So the mediator cannot make any opinion, he cannot make any suggestions, he cannot make any decisions. So these are the key 3 points which we are required to take in mind as a mediator, or in understanding the procedure of mediation. So mediation referred to a process of facilitated negotiation in which a third neutral party, the mediator, assists the disputing parties in understanding and underlying their concerns or needs, and in negotiating a possible settlement of their disputes. So here the mediator role is makes it clear from this statement that when there are the disputing parties, the mediator assists the parties in understanding their underlying concerns or needs, and based on those underlying concerns and needs, the mediator assists the parties or facilitates the parties to negotiate among themselves and reach the possible settlements. So here this statement on the concept of mediation underlies that the mediator is assisting the parties to underlie the concerns and the needs of the parties. He also requests or facilitates the parties to prioritize their concerns, to prioritize their interest, their needs, and based on those circumstances, the mediator facilitates the parties to negotiate among themselves and reach to the possible settlement of their disputes. So, based on this, so we have two authoritative definitions at a global level, wherein Black's Law Dictionary defines a mediation as a private informal dispute resolution process in which the third neutral party, called mediator, helps the disputing parties to reach at an agreement and no power to impose decision. So here again, based on the earlier statements which I have included, the general statements about the mediation, the Black Law Dictionary also defines in the same manner, like there will be a third neutral party who will be assisting the disputing parties to reach at an amicable settlement, wherein the mediator, that is the third neutral party, doesn't have any power to impose the decisions. Even the World Intellectual Property Organization defines the mediation. It is a non-binding process in which a neutral intermediary, the mediator, assists the parties in reaching a settlement of the dispute. So, WIPO, that is World Intellectual Property Organization, also defines it as a non-binding process. Why it is a non-binding process? Because as we all know, and we have already discussed the various features when comparing the mediation with the different types of alternative dispute resolutions, wherein we are highlighted that mediation is a voluntary process. Mediation is a non-binding process. So here, why it is a non-binding process is because the parties are given a facilitative role through the mediator, wherein the parties themselves have to resolve their disputes. And in such circumstances, if at all the parties feels like that this dispute cannot be resolved, or if in case the mediator is tending towards any one of the party, or like he is biased towards the one party, then the other party has a right to quit the mediation at that instance itself. If at all he feels like this dispute cannot be resolved, or in case if the mediator seems to be biased on the other party, the party are free to step out from the mediation room. And this is where we call it as a non-binding process, and there is no law, and even the law cannot impose a binding process of mediation. When we go through each and every legislation, say for example, if we go along with Consumer Protection Act, Commercial Codes Act, Industrial Disputes Acts, Companies Act, the rules which are prescribed, even it prescribes that the mediation is a voluntary process. It's up to the party, and with the party's consent, the mediation process will take place. And if there is no consent from the party, the mediation cannot take place at all. And that is why it is a non-binding process. Even there is no procedural at all. How? Like we elaborate the stages of the mediation in certain circumstances, like we have to go according to the welcome, like then the mediator will provide the opening statement wherein he elaborates about how the mediation procedure will take place. Even the opening statement will build trust of the parties, and thereafter the mediation procedure will take place, wherein the mediation will call for joint sessions. Again, it can call for private sessions. But what happens in a joint session and private session? In case during the joint session, if there is any conflict or if there is any disrespectful among the parties, then the mediator may suddenly call for a private session in order to calm down the parties. So there is no procedure, there is no fixed procedure at all, like the mediator or the parties has to resolve the dispute in a same procedure. There is no procedure at all. So this is where we call it as a non-binding process. And the neutral third party assists in reaching the settlement of dispute, and that is how the World Intellectual Property Organization has defined the term mediation. Even in India, there are various legislations like the Consumer Protection Act, the Mediation Bill, and the Commercial Courts Act has defined the term mediation. The Section 2 Clause 25 of Consumer Protection Act 2019 defines mediation as a means, the process by which a mediator mediates the consumer disputes. So here the term consumer disputes is used because the Consumer Protection Act is only, or the object of the Consumer Protection Act is to protect the consumers, and that is why the term used here is consumer disputes. And similarly, you can find the same definition in case of Commercial Courts Act, wherein the mediation under the Commercial Courts Act, that is Section 12A, and based on Section 12A, the commercial courts pre-institution mediation and settlement rules are been drawn or enacted. The mediation means the process undertaken by a mediator to resolve, reconcile, and settle commercial dispute. Under Commercial Courts Act, it's only restricted to commercial disputes. Under Consumer Protection Act, it's restricted only to consumer disputes. So, I said earlier that a mediation is a non-binding process, wherein the question may arise in order with respect to Section 12A of Commercial Courts Act, which mandates the parties to first resolve the dispute through mediation in case of pre-institution mediation. If at all the matter doesn't resolve, then it can come forth before the commercial courts. This is what the statement which has been laid down under Section 12. Section 12A of Commercial Courts Act. But here I would like to kindly highlight before you all that the Section 12A is very clear that it mandates the parties to opt for mediation. But with respect to the process of mediation, it remains the same. It's still a voluntary process. It's still a non-binding process because it only asks the parties to go to the mediation room to and try to settle out the matter. If the matter is not settled, or if the parties feel that the matter cannot be resolved through mediation, then it can again come to commercial courts. So the procedure of mediation still remains a voluntary process and a non-binding process, whereas it only mandates to try mediation to settle the dispute in case of commercial disputes. Even Section 4 of Mediation Bill 2021 defines mediation that mediation shall be a process whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import whereby party or parties request a third person referred to as mediator or mediation service provider to assist them in their attempt to reach an amicable settlement of dispute. So, here also the Mediation Bill of 2021, which recently passed in Rajya Sabha, even defines the mediation. Here there is a slight concern as to the term conciliation is being used as a process of mediation. So I would like to critique on this with respect to the use of conciliation within the term of Mediation Bill 2021 is because, see, when we go through the whole enactment of this mediation bill or the draft of mediation bill, the section 18 of this mediation bill 2021 provides that the role of mediator in resolving dispute, and here also it defines that. So mediator is a person who facilitates the disputing parties to resolve their dispute, and the role of a mediator is restricted only to provide the views of one party to the other party if with the consent of the party, only under that circumstances he can pass on the views which are being shared by one party to the other party. And in such circumstances, the mediator cannot give opinion, neither he can't make decisions. Whereas in case of conciliation, the conciliator can provide views or can provide opinion or even can provide suggestions under certain circumstances. And that is where I would like to highlight that the term conciliation, which is being used within the definition of section 4 of mediation bill, is somewhat inclusive of mediation, and the question may arise like because the question will arise whether the conciliation will be a synonym of a mediation. No, not at all. Because in some countries the mediation and a conciliation are deemed to be a synonym, but not at all in Indian scenario. Although the term conciliation is being used within the definition of section 4, but when we go through the other provisions of the mediation bill of 2021 like section 18, section 19, yes, the mediation is still a voluntary process, it's a non-binding process, and the mediator cannot provide any views, any suggestion as in case of conciliation. So it cannot, in mediation, the mediator cannot provide any views, any suggestions. And to wrap up the concept of mediation, so mediator is a third neutral party. Mediator is assisting the parties to resolve a dispute. Mediation is a non-binding process. It is a voluntary process wherein the mediator only facilitates the parties to negotiate among themselves and resolve the dispute. A mediation is assisting the parties to reach at a negotiated settlement or an amicable settlement, and the mediation are being defined under various statutes like Consumer Protection Act, wherein mediation term is only restricted for the consumer dispute under the Consumer Protection Act. Similarly, in case of commercial courts, for commercial disputes, the mediation is being defined. And the mediator who resolve, reconcile and settle the disputes. So overall, a mediation is where a mediator, that is third neutral party, assists the disputing parties to reach at an amicable settlement. With this, I conclude here the concept of mediation, and in the next session we will discuss on the various features of mediation. Thank you.